Start. In the light of the aforesaid, the court finds that the petitioner was appointed as a temporary employee but had worked continuously for 9 years. There is an order passed by the controlling authority under the Payment of Gratuity Act awarding gratuity to the petitioner on the ground that he had worked 240 days in a calendar year for 9 continuous years and consequently was entitled for gratuity. This order has become final inter se between the parties. The appointment of a daily wager is a different and distinct from an appointment on a temporary basis. Appointment on a daily wages is on account of exigencies of work, whereas a person appointed on a temporary basis means that there is requirement for work and is not appointed on a day-to-day basis, but the appointment is for a considerable period of time. In the instant case, the court finds from the written statement of the employers that the petitioner was engaged in the electricity department for various projects, and according to the employers, upon the completion of the project, the work comes to an end. The nature of work specified by the employer indicates the temporary nature of work. However, the court finds that this temporary nature of work continued unabated for 9 long years and the petitioner continued to remain a temporary workman. The petitioner alleges that when he came into the zone of regularization, the employers passed an order of termination of the services of the workman. The court further finds that there is nothing to indicate that the construction work in which the petitioner was engaged had come to an end and that the petitioner's services was no longer required thereafter. Para. In the light of the aforesaid, the contention of the employer that the petitioner was only a temporary employee and was therefore not entitled for reinstatement in services does not hold good, especially when no evidence has been brought on record to justify the termination of the workman. There is also no evidence to prove that the project in which the petitioner was employed had come to an end or that there was no further requirement of work. The court further finds that the petitioner, having worked for more than 240 days in a calendar year and having worked 9 years, was entitled for reinstatement in service. The Labour Court has misinterpreted the judgments cited and has erred in granting compensation in lieu of reinstatement. The Supreme Court has denied the relief of reinstatement in those cases where the dispute was belatedly referred for adjudication or where the workman was a daily wager. In the instant case, the petitioner was not a daily wager but was a temporarily employed. The court does not find that there has been an unreasonable delay in raising the dispute. Consequently, considering this aspect, reinstatement in service is the normal rule. Once the order of termination is found to be illegal and is set aside unless a departure is made for strong reasons, reinstatement in service should be granted. The court is of the opinion that this is not a case whether a departure can be made, denying the petitioner reinstatement in service and giving compensation in lieu thereof. In writ petition number 8784 of 2002, Messrs. Hindalco Industries Limited versus Shri Bhuvnesh Kumar Dwivedi and another comma, the court considered the factum of resignation of the workman, and even though he had worked for almost 8 years, held that in the given circumstances was only entitled for compensation instead of compensation. The High Court accordingly modified the award of the Labour Court, granting compensation of rupees 1 lakh instead of reinstatement in service. In writ petition number 8749 of 2002, Messrs. Hindalco Industries Limited versus Surendra Pratap Singh and others decided on 4th July 2011, the court considered the factum that the workman was appointed for limited period of time, and in view of the provision of section 2 in bracket 00 in bracket BB of the Industrial Disputes Act, comma, the court was of the opinion that the workman was entitled for payment of compensation in lieu of reinstatement. A suspicious and defensive approach by the contemner herself cannot invoke sympathies or any other equitable considerations. There appears to be a barrier of confusion in her about her own fate which might have impelled her not to give up her defense. There is no open commitment to an unqualified apology and is hedged by desperate attempts to justify her stand. In spite of the long opportunity available to the contemner, we are surprised at her stolidity for a remorseful apology. The apology is superficial and is only an upholstery with no sense of depth in it. The elements of remorse, repentance, and contrition are what can be described as the life and blood of the bona fide expression of apology. To detest the existence of such virtues for judging an act of contempt is to deprive the law of its morality, which it deserves and which is also necessary to preserve the same. It is like asking to live comfortably in a room with all its air having been pumped out, full stop.